Hi, my name is John Goodman. This is the situation we'd like to consider for this webcast. Imagine you're a real estate broker, you're working with buyers. Over several weekends, you've been driving your buyers around, showing them property. And all of a sudden, as you're taking them back after an unfruitful third weekend, you drive by a house and it has a sign in front of it. And that sign says, "For sale by owner." The buyer is interested in the house. You knock on the door and you ask the seller, "Hey, I've got some buyers in my car. They might be interested in your property. Can I show them around?" Your buyers are looking around the house. You pull the seller over while the buyers are touring the house and ask the seller whether the seller is willing to pay you a co-op commission. And the seller says, "Heck no." You don't argue with the seller at that point. You don't even know whether your buyer is interested in the property, but the story would not be interested unless as you leave the property and your buyers are in the car, your buyers are interested in the property. And what we're exploring today is how you can document the seller's obligation to pay you a co-op commission, how you can enhance the likelihood that the seller will pay you a co-op commission under those circumstances. Now, before I continue with the meat of this, my name is John Goodman. I am a lawyer in Boulder, Colorado. I practice all over that rectangle that we call the state of Colorado. I am licensed in the state of Colorado. To the extent I talk about the law here, laws, especially real estate license law, can vary quite a bit from state to state. While this webcast is not intended to be legal advice at all, it is certainly not legal advice in other states. And for those of you who are brokers working in other states, I encourage you to contact a lawyer who is licensed in your state. All right, here we go. In Colorado, I want to talk about the ideal situation for addressing this situation. And then because life is imperfect, we will work from the ideal scenario to the less ideal scenario, and we'll go from there. So the ideal scenario is that when you're working with this buyer, actually, before I continue, let me say one other thing. This is a situation where the law, at least in Colorado, is the same, conceptually the same. Whether it's a FSBO listing that isn't offering any co-op commission, whether it's a FSBO listing offering less than you would like to be paid, the law is also the same if the property is listed and the listing broker is offering less than you would like to be paid. And don't forget, in really tight markets, these situations come up even when the property isn't FSBO or listed. In really tight markets with high shortages of inventory, there are situations that you run into where you just know a property might work for your buyers. There isn't anything else on the market that would work for your buyers. And you call, you knock on the door, you contact the seller to see whether they're interested. What we are talking about is a situation where the listing broker or the seller or a combination of the both are not offering to pay you anything, or they're offering to pay you less than you were hoping to work for. All right, so ideally, when you run into these situations, this is how you're postured. You have an exclusive right to buy agreement with your buyer. But that's not enough. In the ideal scenario, at least in Colorado, the exclusive right to buy agreement has boxes to check in section 7.3 that addresses who is responsible for paying you, the cooperating broker, the procuring cause broker, a co-op commission. One option is 7.3.2. I'm starting with that one because it's the simplest. And that is the one that obligates the buyer to pay you and does not authorize you to seek compensation from the other side. That is not something that's done very often in residential real estate. It is done more frequently in commercial real estate. I'm not going to spend any more time on that one. There is in Colorado 7.3.1, which is a paragraph that essentially says to the offering broker, the selling broker, the buyer's broker, if you will. It says, broker, try and get paid from the listing broker or the seller, but if you don't, I, the buyer, am obligated to pay you, selling broker. As the exclusive right to buy broker, you want to have one of those two boxes checked, and I am assuming you do in this idealized scenario. You have an exclusive right to buy agreement, you have 7.3.1 checked, and then you also have time, or at least you perceive you have time, to address this issue of who is going to pay you before you submit the offer. Because ideally, it's not addressed in the offer. Ideally, it's addressed ahead of time, and you contact the seller and you let the seller know you have a buyer who would like to submit an offer. The buyer won't be submitting an offer unless the seller agrees to pay you. Hopefully then there's an exchange of emails or letters or faxes, something that leaves a record that indicates if your buyer purchases the property, then closes on the acquisition of a property within certain time frames, then you will be paid a co-op commission. And that is done in commercial real estate. And don't forget to memorialize the amount of the commission. That is done in commercial real estate a fair amount. It's done less frequently in residential real estate because of the challenges that idealized scenario presents. All right, so let's talk about that was the idealized scenario. Let's bring it down a notch to let's add in a flaw. You have an exclusive right to buy agreement. You have it completed in a way so that your buyer is obligated to pay you if the seller or listing broker won't pay you. But your buyer doesn't want to take the time to address this commission issue before submitting an offer. There are two challenges with addressing the issue before submitting an offer. One of them is time, because in the half a day or whole day that out, other buyers may be submitting offers, and your buyer may lose out on the property, and you may lose out in the commission generating. Another problem with addressing it before submitting an offer is that you have less confidence as the offering broker, and your buyer client has less confidence that the seller is getting that the listing broker is communicating with the seller about the situation. Most brokers know that they have to submit all offers to their seller, but some brokers are less than forthright about communicating these commission issues to their seller. An advantage of putting it in the offer is then it enhances the likelihood that the seller will see it. So if after talking to your buyer in this second level situation, your buyer does not want to take the time to address it before submitting an offer, then one of the provisions of your offer, in Colorado we put this in additional provisions, you would put in language that would say something like seller, because remember the purchase contract is a contract between the buyer and the seller. Seller shall cause the listing broker to pay the offering broker a co-op commission of blank % at closing. And if that offer is accepted, then you've addressed that issue. All right, let's move it down a level. In this situation, it's similar to the prior one. You don't want to address it before submitting an offer. But in this situation, you have an exclusive right to buy agreement, but you don't have 7.3.1 checked. You don't have 7.3.2 checked. You have 7.3.3 checked. 7.3.3 is the paragraph that says, hey, broker, if you want to try and get paid, you are welcome to try and get paid from the listing broker or the seller. But if they won't pay you, I don't have to. And what makes that problematic is that when your buyer wants to write an offer to purchase this FSBO in the example that I'm using, you don't have any legal leverage. If you're supposed to inform your buyer, hey buyer, you want to make this offer, they're not offering to pay me a co-op commission. Would you like me to get paid? And your buyer might say, sure, all of the things being equal, I'd like you to get paid, but I don't want to do so at the risk of making my offer less attractive. And there's the rub. If you're doing your job as a broker, you will be telling your buyer client that by inserting language into the contract calling for the seller or listing broker to pay you a commission, you are making your offer less attractive. So if you're still inclined to pursue it, and maybe there are situations where your buyer still wants you to pursue it, that's where you're in a little bit of a dodgy area. And I encourage you to talk to a lawyer to help you analyze the risk of putting it in the contract. There are even worse situations. There are situations where you don't have an exclusive right to buy agreement at all. So the buyer has no obligation to pay you anything. And there are ethical issues about whether you as a broker, even as a transaction broker, can make your offer less attractive, make your client's offer less attractive by inserting language into the offer calling for the seller to pay you. There is even a worse situation, and that is not only do you not have an exclusive right to buy agreement that not only do you not have an exclusive right to buy agreement, but you don't in Colorado, you're supposed to have a disclosure to your buyer who you haven't signed up to an exclusive right to buy agreement. You're supposed to have a disclosure to them talking about your brokerage relationship. If you don't have one of those disclosures, you're even more vulnerable because if skirmishes come up later, it's something that gets added on to the pile of things that you violated. Now, suppose your buyer would like to see you get paid. Can you write the obligation for the seller to pay you in the offer? And the answer is, this is governed in Colorado by Real Estate Commission Rule F2. And F2 has an A and a B. And I don't usually read to people as I'm teaching, and especially in a webcast, but this is short and it's important here. F2A says, the additional provisions section of the commission-approved form must contain only those transaction-specific terms, well, that's not a problem, this will be transaction-specific, or acknowledgments that result from the negotiations or instructions of the parties to the transaction. So when your buyer wants you to write it into additional provisions, you need to get email confirmation from your buyer that they want you to do it. That's the best practice. B, a broker who is not a principal party to a contract may not insert personal provisions, et cetera, into a commission-approved form. Well, in this buy-sell contract, you are not a principal to the transaction. The principals are the seller and the buyer. You're the broker. You're not a principal to the transaction. And if you fail to set yourself up in a situation where your buyer is obligated to pay you, this is a personal provision. It's not clear that a buyer can make an informed decision, waive what's in their self-interest to allow you to write an offer that calls for them but makes your offer less attractive. If you are in one of those situations, again, I repeat, where you either don't have an exclusive right to buy agreement or you have an exclusive right to buy agreement and the boxes aren't checked in a way that obligates the buyer to pay you if the seller or listing broker won't, then you need to talk to your lawyer to figure out the risks on a case-by-case basis. Thank you very much for listening to this webcast. We hope you catch us on the next one.